Exclusive licence for patent technology, extremely valuable to the creative economy of Australia. Protection of innovation is vital. There are ways to allow use of patent technology once you have sought out protection, one of these being a licence. A licence does not transfer ownership from the patent owner to the licensee, it simply gives permission for the use of the patent. An exclusive licence is described as a licensee under a licence granted by the patentee and conferring on the licensee or on the licensee and persons authorised by the licensee the right to exploit the patent innovation throughout the patent area to the exclusion of all others. Exploit is defined as to make, hire, sell or otherwise dispose of the product. The grant of an exclusive right brings with it the indicia of ownership. Patent owners essentially surrender patent rights to the licensees. The exclusive licence creates a proprietary right rather than merely a contractual right that a non-exclusive licence creates. The rights granted are as followed. Consent or without consent to amendments of the complete specification. Commence infringement proceedings. The patentee must be joined as a defendant unless joined as a plaintiff. Contest non-infringement declarations. Contest the grant of a compulsory licence. There are some limits to granting an exclusive licence over patent technology. The exclusive licence may be limited on the field of use or for a specified time or by territory. The case of Darmagold versus Jai Products highlights the importance of describing the party relationship in proceedings. The licensee Vertilux Corporation wanted to launch an action against Jai Products for patent infringement. The agreement stated that there was an exclusive licence granted to Vertilux. Jai argued that Vertilux was not an exclusive licensee because there was a pre-existing licence agreement between Darmagold and the third party. Evidence showed that the earlier licence from Darmagold to the third party was only to sell particular products overseas and not in Australia. Court held that Darmagold's licence to the third party did not affect Vertilux's status as an exclusive licensee. Another limit imposed upon the exclusive licensing right of a patent owner is that all rights must be exploited. If any rights are retained by the patent owner, then the licensee cannot enjoy the rights granted to those with an exclusive licence. In the case of Bristol Myers Squibb versus Apotex, the court determined the meaning of the exclusive licensee and of exploiting rights. The court considered whether Bristol Myers Squibb was an exclusive licensee over a patented antipsychotic agent from Otsuka Pharmaceutical. The license agreement between the two granted extensive rights over various patents, including the patent in question. But Otsuka reserved the right to manufacture the antipsychotic agent. Court held that as all rights to exploit were not granted, this meant it was not an exclusive licence. BMS argued that if they had an exclusive licence with respect to one of the rights afforded by the patent, then they should be able to enjoy the rights of the Australian Patent Act. The court rejected BMS's argument and defined right to exploit in section 13 as being one indivisible right, and although the right to exploit can cover a number of activities, it does not separate the rights because of this. A further limitation is that only one exclusive licensee can be appointed by the Patents Act. This was affirmed in the case of Reimpartial Chemical Industries Limited, ex parte British Nylon Spinners Limited. How is an exclusive licence granted? To establish whether an exclusive licence has been granted, we must look to the rights that are afforded to the licensee. When entering into a new licence agreement, the patentee and the licensee will need to negotiate the precise terms of the rights and obligations in relation to the patent. Once an exclusive licence agreement has been formed, the licensee can request registration of his or her interest in the patent. This can be done by an application under Section 187 of the Australian Patents Act. This involves filling out a form and providing evidence to support this request and submitting it via post or through online submission. In conclusion, exclusive licence can be granted over patent technology. They create prima facie ownership rights for the licensee. However, there are a number of limits imposed on exclusive licences. They can be granted by making an agreement with a patentee and then can be registered with the Australian government.